Good evening, everyone, and welcome to the Maryland Coalition for Justice and Police Accountability Informative Town Hall. Our coalition is made up of over 90 diverse organizations, which have come together to demand real police reform and accountability in the Maryland state level. We are joined tonight by 5 extraordinary panelists who will support us in providing an update on our 5 statewide police reform priorities and where they currently stand with the House and Senate police reform package. I want to take the time to remind everyone who is watching tonight, first off, to congratulate you for being in the space with us together, as well as remind everyone of the 5 priorities we have been advocating and fighting for, which include the full repeal of the Law Enforcement Officers' Bill of Rights, return of the Baltimore City Police Department to Baltimore City. We are continuing to fight to limit the use of force by law enforcement, remove police officers from our children's schools, as well as making investigations into police misconduct transparent. There will be an opportunity this evening for us to, after hearing from the panelists, have some questions and answers. So during the panelists' presentations, please utilize the chat box to upload any questions that you have pertaining any of the presentations or updates. We will have a segment after the panelists have an opportunity to speak to hear directly from folks watching at home, and we will be answering those questions live during the informative town hall. And additionally, you are able to receive more detail of all of the 5 priorities I just mentioned by visiting the coalition website at mcjpa.org, where you can find additional talking points, videos, and explanations, toolkits, and issues on all of those 5 policing priorities. This town hall is also being streamed on the MCJPA Facebook and Twitter, and we encourage everybody at home to share because this legislative session is not over yet, and collectively, we are continuing to pressure legislators to ensure real police reform during this legislative session. I want to take this time now to turn it over to Davon Love, who is the Policy Director of Leaders of a Beautiful Struggle, who is going to recap with us where the full repeal of the Law Enforcement Officers' Bill of Rights stands. Davon?
All right, thanks, Lydia. Peace to all those that are watching this. We appreciate you all, joining us for this. What I want to do first before I talk about the Maryland Law Enforcement Officer Bill of Rights repeal and the status of that work in the Maryland General Assembly, I want to take a moment just to talk about the coalition's frame and approach to the issue of police reform, because that's vitally important in putting in perspective and in context the demands that Lydia just listed off. It's important to note that over the past several years, the issue of police brutality has kind of emerged to the fore of American political discourse. And we've been inundated with narratives and images of Black people being killed at the hands of law enforcement. And there are a variety of different perspectives that one can take when addressing this issue. Some folks have taken the approach of trying to get this society to recognize the humanity of people of African descent and people of color more broadly in a way that structurally the society does not. Some people take the approach that we need to address this from a perspective of improving community and police relations. There's some folks that approach this issue from the vantage point of protecting people's civil liberties. This coalition has chosen to take the perspective of rooting our advocacy in the traditions of racial justice on the issues of police accountability, because we know these are not new issues. So whether we're talking about the Black Panther Party for Self-Defense and how they took it into their own hands to patrol police that were abusing people in their neighborhoods, whether we look at the advocacy of many of the traditional historic civil rights organizations, of which in response to many urban rebellions around the United States that during the 60s, that started, many of them as the result of an instance where a police officer killed or did significant harm to a Black person, and the advocacy that emerged from many of these traditional civil rights organizations on the issues of policing have to do with the importance of putting power into the hands of the community as paramount when we think about the issue of racial justice and what that means. And so we're going to discuss a variety of different things this evening as it relates to many of the important demands that have been made during the Maryland General Assembly and that the 90 organizations that are members of this coalition have put forward. But we want to make clear that the standard that we are using as the metric for what constitutes success in its highest form is rooted in the kind of continued struggle for racial justice that, again, is essentially about putting hands in the power of the community to be able to put consequences against police officers and the institution of law enforcement that has done harm to folks in our community. Many of us who have been advocating the repeal of the Law Enforcement Officer Bill of Rights and changes to it over many years have done so primarily because it is one of the major impediments to the ability for the community to have power over law enforcement. That the Law Enforcement Officer Bill of Rights, one of many things that it does is that it, as it's currently constituted, is that it structures the process for disciplining police officers in such a way where the institution of law enforcement controls the entire process. So the repeal of the Maryland Law Enforcement Officer Bill of Rights, the purpose of it wasn't just the idea of standardizing different kinds of police discipline around the state. That's one part of it. But for those of us in the community who've been pushing to have this LEOBR repeal, many of us have been pushing for it so that the community is able to exercise real control over investigation, discipline, and adjudicating discipline for police officers. After this summer, when it became clear that the LEOBR repeal was something that was going to be something advocated by both presiding officers, the Speaker of the House of Delegates, Adrian Jones, and the Senate President, Bill Ferguson, it became clear that what was equally important is what to replace it with. And so a simple repeal became clear that a simple repeal was not sufficient to ensure that communities were able to actually exercise the power of the communities and be called out for. And particularly in jurisdictions whose politics tend to be more conservative, the fear would be that the Fraternal Order Police will be able to structure agreements around the state in a variety of different jurisdictions to produce LEOBR-like elements within their collective bargaining contracts. So this was, again, why it was important for us to not just focus on the repeal, but to focus on the replacement language, to focus on what it was that was actually going to replace the LEOBR. So with that, I'll move to just some updates as to where we are and where we have been in terms of the legislation that has been put forward in the Maryland General Assembly. So first, I'll start with House Bill 627. This was a bill that was introduced in the Senate, sponsored by Senator Jill Carter of the 41st District, with the purpose of repealing the LEOBR and providing replacement language. Before I go further into the bill, I want to discuss a part of our perspective as to how to structure the replacement language, because there is no process that one can establish where if the actors within the process are problematic, that it doesn't result in the lack of accountability and transparency. What we understood was that the more power that we can give the public, the community, to exercise its will, the better. And so this was particularly important. And a part of why what you'll hear, after me, you'll hear a discussion about the Maryland Public Information Act. The idea of giving the public as much information as they need, but for the purposes of this piece of legislation was to give the community the ability to exercise the greatest level of control and power. So what SB 627 originally was intended to do was to get rid of police trial boards altogether, diffuse decision-making in terms of discipline within the police chief, provide a statewide standardized process for discipline that would go across the state, that would make it so that jurisdictions could not develop subjective procedures for discipline, such to both ensure due process for police officers, but to make sure that police were held accountable, and then create the ability for jurisdictions to establish community oversight entities via and local ordinance of their local legislature, such as the community can be a part of co-designing a process for developing an external entity that would be able to impose discipline. Unfortunately, what we got out of the Senate Judicial Proceedings Committee and ultimately off the Senate floor was a very compromised bill of 627. This compromise bill included the reinstatement of police trial boards. These are, or hearing boards, these are internal hearing boards from which when a chief gets disciplined, the officer refuses, this board then emerges to then provide discipline, to hand down discipline. What the Senate will argue is that it's a 3-person board with an officer and 2 civilians. Bill doesn't specify how those civilians get there. I'll talk about this towards the end, but those 2 civilians are still operating within a police law enforcement process and only come into play when an officer rejects discipline. So this may be civilian participation, not oversight. Additionally, there are other FOP amendments that were included in the bill that are remnants of the LEOBR, which include things like not requiring officers to have financial disclosures. Those are the kinds of things that would be helpful when we think about the Baltimore City Gun Trace Task Force, where officers were engaged in drug dealing, selling drugs and stealing money. So these were the kinds of remnants of the LEOBR that remain. Most importantly, they gutted the community oversight function. So they essentially struck the part of the bill that would have allowed jurisdictions to create external entities that the community would own and operate that would be able to impose and adjudicate discipline on law enforcement. So what I mentioned, we, as many of you probably have seen the write-ups that have been done about Senate Bill 627, the coalition was very disappointed in what was produced out of 627, both in terms of gutting civilian oversight. Additionally, so what I'll do now is I'll talk about House Bill 627. And what I'll do in doing that, because I'm going to come back to this notion of community control towards the end for the purpose of making it very clear the distinction between the position our coalition is taking and the position that many of those in leadership in the legislature are taking in terms of how we're defining that term. In House Bill 627, while our coalition would argue that there's greater levels of civilian participation, in that they do something similar to what the Senate did in terms of reinstating trial boards, having an administrative law judge and a civilian in addition to a police officer on the trial boards. I already discussed why the trial boards are problematic. They add this body, this charging committee that will be composed of 5 civilians selected by government, 3 of which selected by government agencies, the city solicitor, the state's attorney, the office of the public defender, the chair of the police accountability board that I'll talk about in a moment, and an appointee from the police accountability board. Those charging committees would have the role of reviewing the investigations of misconduct of law enforcement officials. That role is for us, again, civilian participation, not oversight. Again, I'm gonna get to exactly what that is towards the end. And again, I just wanna make sure I'm reminding people right now, I'm talking about House Bill 670, which is the House version. In addition, they create the mandatory creation of police accountability boards, the composition of which will be determined by a local ordinance. These police accountability boards would get quarterly meetings with law enforcement. And again, the chair would serve on the charging committee, and they would appoint a member they would appoint someone, a civilian, to the charging committee. These police accountability boards, while between the House and the Senate, the Police Accountability Board in its form is the closest to what we would consider community oversight. The problem is that it has no power to impose discipline. It has no power to adjudicate and impose discipline, which for us is paramount. So when we talk about this issue of community control and community oversight, and again, this goes back to the beginning statement I made as the general frame of how we're coming to the issue. The ability for the community to fire a police officer for doing them harm is the greatest deterrent against police abuse. All of the other things that you're going to hear about tonight are important and meaningful things as it relates to addressing the issue of police misconduct. But if the community itself is not given the power that it deserves to impose discipline on an agency that is supposed to serve us, then that falls short of the metric of racial justice. And so community control would be most constituted by an external entity that would be able to impose discipline that isn't prescribed by a state governed process, but something that the community would be a part of creating and imposing discipline. And this is what is lacking from the LEOBR replacement language that is put forward both by the Senate and the Maryland House of Delegates. So that's our position on the LEOBR replacement language. I guess I'll kick it back to Lydia.
Thank you so much, Davon, for that overview and that full summary for folks to be able to grasp at home, and also for us to uplift and continue to put that pressure. I'm going to turn it over now to the public policy advocate at the ACLU, Yanette.
Lydia. So in addition to repealing the Law Enforcement Bill of Rights, the Law Enforcement Officers Bill of Rights, another big priority of ours was reforming the Maryland Public Information Act, which is also known as Anton's Law. Currently, Maryland's Public Information Act categorizes police disciplinary records as personnel records, and personnel records are always confidential. And so the goal of our bill, which was SB 178 in the Senate and HB 120 in the House, was to reform Maryland's Public Information Act and move these police misconduct records from the may not disclose category to the may disclose category, so that the public has transparency over how police departments investigate misconduct complaints. So in the Senate, the Senate actually passed out a clean version of Anton's Law. There was only a small amendment that was amended onto the bill in committee, which was to carve out technical infractions. And technical infractions are defined as a minor rule violation by a person employed by a law enforcement agency that solely relates to the enforcement of administrative departmental rules that do not involve interactions with members of the public, is not a public concern, and otherwise is not connected to the person's investigative enforcement training, supervision, or reporting responsibilities. So this was an amendment that we were okay with, and that's what the Senate passed out. Now in the House with HB 670, Anton's Law was amended onto HB 670, but in addition to that, there were other amendments that were included in the bill, which we have concerns will have the potential to create barriers to the public having disclosure over records. So an example of that is the amendment gives the public, the MPIA, the PIA Compliance Board, the power to allow the custodian to deny records if they believe that those records are frivolous, in bad faith, or fictitious. And so we have some concerns about how that could potentially create some barriers, and are working to try to get the House to just concede to what the Senate's version of MPI reform. And that's still ongoing, and that is something we'll get into later about how you all can support us in making that happen. And it's pretty much it for the MPI portion.
Thank you so much, Yanette, for that overview. We're now going to hear from Joe, Policy Counsel for the ACLU. Joe?
Thank you, Lydia. So our next priority is creating a statewide use of force statute. As many of you know, Maryland right now is one of only 9 states without statutory limits on officer use of force, which means that use of force in Maryland is governed solely by Supreme Court case law, which authorizes force when it's objectively reasonable, which is too low of a bar. We've seen that it completely fails to protect people in Maryland, and it gives way too much deference to the officer to say that force was reasonable under the circumstances. So our main goal was to raise the legal standard to authorize force only when it is necessary after exhausting reasonable alternatives. We also wanted very clear definitions of terms like lethal force to include all the different types of tactics that officers have used to kill people in Maryland. And we wanted to ensure that there's an explicit civil right of action for people against whom force has been used unlawfully. So throughout the summer and fall, we worked closely with Senator Jill Carter and Delegate Deborah Davis to create a really strong statute, which is SB 66 and HB 139. The problem is that the Senate completely gutted our bill. There are a couple of good things in the Senate bill that we like. Clearly, they amended on Senator Carter's whistleblower protections bill, which is a good thing. However, as far as use of force is concerned, the Senate completely gutted that part of the bill. So first, not only did they fail to raise the legal standard, they actually ended up creating an entirely new standard that is both weak and also unconstitutional. So they established a new definition of excessive force that would allow officers to use force merely to gain compliance or control a situation. So this goes completely against the Supreme Court ruling in Tennessee versus Garner. In that case, the Supreme Court says that, for instance, an officer can't just shoot someone who's running away to prevent them from escaping. There must be probable cause that they pose a significant risk of death or serious physical injury. But in that same situation, under the way that the Senate bill is drafted, an officer would be justified because it is likely necessary to gain compliance and control that situation. The second thing is that the Senate bill says that officers may not intentionally use excessive force. So in addition to weakening the standard, this means that officers would not be held accountable for using excessive force simply because of their negligence. There are still some efforts to create a duty to intervene and provide medical treatment, but even those standards were watered down. And then lastly, there are some training and reporting requirements for law enforcement agencies, but those requirements are tougher to enforce because the Training and Standards Commission would have to find that an agency is out of compliance and then give them an opportunity to become compliant before they're eligible to lose any state funding. So in short, SB 626 is now basically a whistleblower protections bill with an unconstitutional use of force statute and weaker standards that are largely unenforceable. I think Senator Charles Sidnor said it perfectly when he voted against it. He said, "I don't know how this bill protects me," and he's absolutely right. However, we were much more successful on the House side and basically ended up amending almost all of our entire bill onto the Speaker's bill. So as it currently stands, the legal standard now says that officers may not use force unless it is necessary and proportional, only after exhausting reasonable alternatives, and must stop using force as soon as possible. And officers may not use lethal force unless it's necessary as a last resort, again, also after exhausting reasonable alternatives. There's an explicit civil right of action written into the bill. There are clear definitions from our bill of terms like lethal force, again, to include all of the different tactics that we've seen officers use. There's a duty to intervene, duty to provide medical aid or obtain medical assistance for anyone who's injured in a use of force incident. There are reporting requirements. Officers must fully document all use of force incidents, and supervisors must collect and review all video recordings of use of force incidents. There are training requirements. So the Training and Standards Commission must incorporate into their training curriculum, training on the proper use and level of force as is set forth in the bill, as well as de-escalation tactics and other reasonable alternatives to the use of force. The Training and Standards Commission is also authorized to suspend or revoke certification of officers who violate the use of force statute. And the commission also has to hold agencies accountable for violations of the statute. They have to submit an annual report to the governor and the General Assembly that lists every agency that did not comply with the use of force statute and describe the nature of that violation, and then work with the comptroller and the governor's Office of Crime Prevention to withhold state funding from those agencies. So moving forward, as we go into conference committee, we'll be pushing really hard for the Senate to agree to the House bill with the additional data collection and reporting requirements that are currently in the Senate bill. But I think especially because the bill that came out of the Senate was such a mess and the House did a good job of cleaning it up and actually fighting for it, I think we're in a really good position, and we're hopefully optimistic that this bill will look really strong once it's finally passed.
Joe, thank you so much for that recap as we summarize where we stand with the priority our coalition continues to push in use of force. Our coalition has also been continuously fighting for and pushing for police-free schools. And I want to present Monisha from the Public Justice Center, who will be giving us a summary of where we are with the two different legislations.
Thank you so much, Lydia. So our fifth demand is to get police out of Maryland public schools and reinvest in interventions that actually support positive student behavior and peaceful conflict resolution. And this too is an issue of racial justice because we know that Black students face school-based arrests at severely disproportionate rates statewide, even though there's no differences in behavior across race. Basically, police presence in schools is criminalizing children for acting like children, being disruptive or getting into those run-of-the-mill fights, and this is particularly acute for children of color. As Lydia mentioned, the strategy on the demand involved 2 House bills this year. House Bill 1089 represents really our ultimate goal, a state-level full prohibition on police being stationed in schools and a full shift of the $10 million per year state school police fund to student mental health services, wraparound supports, restorative approaches, all of which have been shown to actually make schools safer. And then there's House Bill 496, which focuses just on that second piece, the funding shift. Complete removal of police is our ultimate goal, and we've made that clear in all our messaging across the board. But both our sponsors and the coalition felt that given that this is the first year for both of these bills, if we could at least accomplish the redirection of state funds, that would be a very valuable stepping stone for moving the ball forward and supporting local county level police-free schools movements that are underway already. So we're still at the committee stage in Ways and Means on both bills. We had a great couple of hearings with students, parents, educators from really around the states testifying in support. Very little opposition, particularly on 496. We've talked to a number of committee members on Ways and Means and EHE, where the bills would go in the Senate, who have been supportive of one or both pieces of legislation. However, Ways and Means leadership has said that the bill they're planning to move is a third bill, House Bill 522. Now, House Bill 522 simply states that SROs, or school police officers, should not be involved in student discipline. We understand where the proposal is coming from. It grows out of a recommendation issued by the Maryland Commission on the School to Prison Pipeline some years ago. And the sponsor is the Vice Chair of Ways and Means, Delegate Alonzo Washington, and we know he has been a champion on issues of restorative justice. The problem is that all the largest school districts, and at least half of all districts overall, already have adopted a prohibition on SRO involvement in discipline as set forth in 522. And actually many more districts likely have this very same prohibition. We just can't confirm that because they don't make their SRO policies or MOUs available online. And yet, despite that language in place in most of the districts across our state, the existence, or rather, we continue to see problems with over-policing of children, arrest in circumstances that really should not be handled in that manner, and so on. And it's actually not that surprising because legally there isn't a clear line between what's a discipline issue versus what's a criminal law matter. Again, those fights, those disruptive behaviors can all be characterized as crimes if you're a law enforcement officer whose job is to view conduct through the lens of the criminal code. We do believe that House Bill 522 is going to get a committee vote soon. And we have been told that this is sort of the vehicle through which the committee is inclined to move school policing this year. So we're really pushing to at least get 496, the funding shift, amended into that bill. And we're talking about, again, a full redirection of the state SRO fund towards student mental health services, wraparound supports, and restorative approaches. State dollars shouldn't be going towards school police, given that they've been shown not to be an effective safety tool or and do clearly cause harm, as I described before. And we also want to be really clear that it's not enough for the fund to be made optional. We have heard some talk that the committee may be looking at a proposal to allow districts to choose whether they want to draw down those state funds for school policing or for the types of student supports and services that we think are critical. And the concern there is that this really doesn't move the ball on the issue. Districts will have no incentive to shift away from school policing if they can still use the money to fund that work. And the worst offenders will continue to use that free money from the state to expand their programs. We've already seen them in some counties expand SROs down to the elementary school level using the state dollars. So at this point, our call to action is really to push lawmakers to enact 496 by way of full incorporation into 522. And as we're doing this, we're making absolutely clear that police-free schools is the ultimate goal, and we're continuing to push and advocate on that. And we'll likely need to come back to Annapolis on that issue next year, by which time we hope to have some gains in certain counties that right now are considering complete abolition of police from their schools. So that's our call to action at this point. And we've got sample language which we can share so that you can get in contact with your lawmakers on this issue. Thanks so much.
Thank you so much, Monisha, and thank you so much for also uplifting that call to action. We will now be hearing from Baltimore City community organizer with Organizing Black, Rob. He's going to be talking about bringing local control back of Baltimore City Police Department back in the hands of Baltimore City.
Thank you, Lydia, and thank you to all in attendance today. I guess I'll just first start with framing the history for those of who may not be fully aware. In the 1860s, state officials took control of the BPD after a violent white male nativist party, the Know Nothing Party, gained political power over the city and were engaging in acts of corruption throughout the police department. And over the years, Baltimore officials have tried to regain control of the police department, but haven't really been successful. So we're trying to gain local control, and what that would look like would be allowing the city council to pass ordinances to govern the police department, which we currently cannot do. And it would put Baltimore on par with every other jurisdiction in Maryland, which currently has the control to locally govern their police department. The status of the local control bill in the House and the Senate, SB 786 and HP 1027. They're sponsored by Senator Cory McRae and Delegate Melissa Wells at the request of the mayor of Baltimore, Brandon Scott, would establish BPD as an agency of the city of Baltimore. Essentially, the caveat is the bill would actually only create an advisory board that would review the nature of the transfer and provide recommendations for implementation. And the citizens of Baltimore would have to pass a ballot measure in our next election cycle to fully implement that. That's something that we've kind of understood and agreed upon, that this is what the best that we can get in this particular moment. The composition of the advisory board is as follows. There's one rep from the BPD, one rep from the FOP, the Fraternal Order of Police, 3 community members, 1 city council member, 1 community oversight task force member, 1 civilian review board member, 1 city law department official, and 1 non-voting consent decree monitoring member. The Senate bill passed with amendments and is about to cross over to the House for consideration. The House, the city delegation approved an amendment that would make the bill like the 2019 local control bill, which passed unanimously and died in the Senate. And this has not yet been discussed or given a vote in the Judiciary Committee. Essentially, what we demand is to bring the local control back to the city of Baltimore. And while we understand there's a slight difference between the Senate and House bills, we want to be very clear that our goal remains the same. Ensuring that local control of the Baltimore City Police Department is achieved as soon as possible. And that is up to both Baltimore City leadership and the state leadership to work together to ensure that it passes the session. It's kind of ironic that the racism and the white supremacy of the Know Nothing Party is what led to state control of our police department, and that the state control serves to uphold racism and white supremacy today. The people of Baltimore want and deserve the same as every other Maryland jurisdiction, local control. And we know that the time to get it is now in this particular moment. But in this moment, we actually need collaboration and action for our elected officials. So our call to action is really just to call and email all of your elected officials and push them to pass local control as soon as possible.
Thank you so much, Rob, for that update. And thank you so much for everybody at home who has been sending the questions through the chat. We are now at the question and answer portion of the community town hall. So if you haven't yet put any of the questions in the chat box, please feel free to do so. We will be now starting that portion. We are going to turn it over to Yannette, who's going to lead us in that question and answer segment of our town hall.
Thanks, Lydia. So the first question of the evening is for you, Davon. Friendly delegates repeatedly argue that allowing local jurisdictions to create civilian oversight bodies risks oversight bodies in conservative jurisdictions that would be stacked with conservatives and dilute police oversight and discipline. How can we respond most effectively to this argument?
So that's a very good question. And it's something that I think, those of us in this coalition that have been working on the LEOPR replacement language thought long and hard about. It's important for those of you who are interested in that question to remember that that House Bill 670 mandates the creation of police accountability boards throughout the state. So this problem that has been flagged by some of our friendly delegates, it's important for them to recognize that this is a problem that the speaker's bill does not solve. And in fact, because they mandate the creation of these police accountability boards, that is actually more of a problem with what the House has passed than what it is that we have proposed. This coalition had proposed in the original language of Senate Bill 627 that jurisdictions should be allowed to, by ordinance, develop these entities that would create these community oversight bodies, not requiring it. Because if you require it, then that's where you run into the problem that the question implies around conservative districts, essentially allowing, this is kind of hyperbolic, but allowing Klansmen to usurp police powers. We suspect that in more conservative districts, they're more likely to be more pro-FOP and more pro-traditional law enforcement. So we don't think it'd be likely that they would want to step on the toes of a police chief that they're likely to be supportive of. And so we think you don't mandate it, because if you mandate it, you run into that problem. But again, I just want to emphasize, because this is something that I think is, I don't know if it's intentionally being misunderstood by those, by those in leadership and communicating to friends of ours, but it's important that people are clear that what the House bill doesn't circumvent that problem. All of the charging committees that are selected by agencies in those jurisdictions are going to be selected from those same conservative jurisdictions. So neither proposal completely avoids this problem. We just think our proposal is the best way to address it.
Thank you. We have one other question for you, and that is, who selects the individuals who end up on the oversight board?
So in what the coalition had put forward initially in 627, that would be developed by an ordinance. So a local council would have to establish an ordinance that would determine all of that. Those are the kinds of things that I think each jurisdiction, depending on its population, depending on its needs, depending on the different mechanisms of government that exist in those jurisdictions. Baltimore City has a board of estimates. That might not be the case in Carroll County. So there are different entities that have different jurisdictions that have different governance structures. So the idea is that a local ordinance would allow the community and the local government to come to an agreement as to what that looks like. That's also the process that the House in House Bill 670 adopted, where the composition of the police accountability boards that they mandate are selected by a local ordinance.
Thank you. And this next question goes for Monisha. The question is, if we get rid of school police officers, what can be done in the absence when police are needed?
Yeah, that's a great question. So it's important to recognize that neither of our bills is looking to prohibit schools from doing what essentially anyone else can do when there is an emergency. They can still call the police to come respond to an emergency event. They can also even proactively sort of plan with local police departments for adequate law enforcement coverage. So, say before the school year starts, have an officer do a walkthrough before, classes are filled and students are there, so they can get to know the campus, know their points of contact, respond, so they can continue to coordinate in that way, and again, call in an emergency. So the difference is we know from districts that have actually taken that approach of getting their officers out of the classroom and relying on emergency calls only. We know that when we actually make that shift, we see arrests decline for normal childhood behaviors because you don't have an officer witnessing them as they happen. You don't have a teacher who's too stressed to deal with the issue, just taking the easy way out by calling the officer down the hall to respond to the disruptive kid, because that officer isn't there. And we're being more selective and careful in calling only in a true emergency. And the other thing I'd highlight is, well, let me add two more things. The bill also would not prohibit the use of security guards. That's, in a lot of districts right now, we've got both police officers and security guards. We are really, in many ways, you hear kids talk about why it feels more like a carceral setting than an educational setting, because we've got layers upon layers of security. Taking out the police would not prohibit the retention of unarmed security guards that do not have arresting powers, if that's what a district wants to do. But the other piece is that what our bills look to do is really invest in those types of preventative, proactive supports that prevent, that eliminate the need to rely so heavily on police response, right? So we know from extensive research that one reason kids act out, may respond in aggressive manners, is because they've suffered trauma. But when we actually implement trauma-informed practices in a comprehensive way, when we actually have mental health services on site and on campus readily available to those kids that need them, they're no longer responding with that fight or flight response to a trigger, and they're resolving and they're regulating their emotions and resolving conflicts in more peaceful ways. So it doesn't even get to the point where police involvement is needed. Same goes for practices like restorative approaches that strengthen relationships within the building, and just the provision of wraparound supports. All these preventative measures reduce the need to use punitive and police-based responses, overall, and that's really ultimately what's going to make all our kids safer.
Thank you, Manisha. And so this next question goes to either Davon or Joe, or both of you can answer. For the bills that were watered down, mostly Leo-born use of force, is it better that they don't pass at all, or is there a plan to build on these bills next session and hope for incremental change?
You want to start, Joe, and I'll go after you. Is Joe there?
Sure. So for the use of force bill, again, it was completely watered down on the Senate side, but the bill as amended onto the Speaker's bill on the House side is looking really, really strong. So that's the one that we're going to be supporting moving forward.
For the LEOBR replacement language, that's actually a really good question. And I don't even know that the coalition has discussed as a coalition a possibility of not wanting either of them to pass. So I think that's a tactical consideration to make. I will say though that I think regardless of what happens this session, I think it is the intention of many of the organizations in the coalition to pursue the achievement of community oversight, regardless of what happens, via conference committee and what ultimately passes this session in the future.
Thank you. And so this question goes to Rob. Why is it that Baltimore City legislators oppose return of city police to the city? Isn't the cost argument a false one? Returning responsibility to Baltimore should reduce lawsuits since control could reduce bad actors and behavior by police officers.
Our friends at the ACLU have told us a number of times that it is a false argument, but it's an argument that for some reason just keeps coming back to us. I don't know that it would necessarily immediately reduce the number of lawsuits that we would have, because a lot of other policy changes need to happen to actually get that, to change their practices and the way they police our communities. So it's like, it's not just one thing that needs to happen, it's multiple steps, right?
Thank you. And so one other question for you is for local control is, what would you say to people who argue that they agree that the state agree with the state keeping control of the Baltimore City Police Department because Baltimore City can't manage anything?
I'd say that's just a racist argument that Black people can't manage our own business. And yeah, there's nothing really else to say to that.
This next question is for you, Davon. Community Police Advisory Boards, HB 670 requires counties to have a PAB that reflects the county's diversity, and the coalition does not specify. So why is the coalition's proposal better?
Couple things. One, if the issue is to avoid conservative folks usurping power to impose harsher discipline, what is in House Bill 670 mandates the creation of these bodies. So these entities, Black folks or folks of color in those more conservative jurisdictions who are in the minority would be better served with the traditional law enforcement structure and not adding and mandating a body that will be partial in the opposite direction of police accountability. To the particular piece around the requirement to reflect the demographic of the county, number one, that's not something that the bill provides an enforcement mechanism for. And secondly, I don't know that there's any evidence that when you talk about the demographic diversity in the jurisdiction, if it's a majority Black jurisdiction, it's more than likely going to be something that will reflect the people in that jurisdiction if it has to be done via a local ordinance. So that's part of the rationale why that was the process we took, because it provides the greatest ability to more authentically represent the jurisdiction. There's no state sanctioned process or mechanism by which the diversity requirements, and again, in House Bill 670, it doesn't provide like an enforcement mechanism, a metric for how you determine demographics. And ultimately, I think what folks are more concerned about is the power, the community having the power to impose discipline. So an entity that's created by an organized segment of the community that is able to impose its will on a local council, we think that creates better opportunity for accountability than mandating it in bodies that, or in districts that are going to be less partial to the issue of police accountability.
Thank you. This might be another question for you as well. I know there was an amendment proposed to add a community review board to the House package. Was that voted down by Judiciary Committee or by all House delegates? Is there a place where we can see where what legislator voted against this amendment?
There was an amendment by Delegate Acevedo to give the police accountability boards power to investigate and to adjudicate and impose discipline on law enforcement. So that's the amendment that I'm aware of that was read on the House floor. It was an amendment that was not read or proposed in the subcommittee or the full committee. It was read on the floor. We have no way or no record or to put anybody on the record in terms of who supported it, because the amendment on the floor did not receive a roll call. So we don't have any way of having folks on the record as to who supported it and who did.
This question is for you, Monisha. Would security guards be necessary if social workers were in schools?
I don't think security guards are necessary. Many schools don't have them. And so that's certainly not sort of the position of the legislation that they're required or that they're needed. It simply doesn't abolish that, option. Neither bill would do that. And yes, you're absolutely right that, part of the reason we're coming to the General Assembly with these concerns about school policing is because we know across the board and across the state, Maryland falls short of the recommended ratios of social workers to students, counselors to students, nurses to students, school psychologists to students. In every one of those categories, we fall short. Not to mention that, positions like restorative justice coordinators or facilitators simply don't exist at all at most schools. So I absolutely think that if we actually had social workers and other professionals who had the time, who were staffed at a level that they each had the time to attend to students' mental health needs and help them help to resolve conflict and facilitate social emotional growth, which really is part and parcel of school along with the academics, then there would be less need for sort of punitive, law enforcement based security.
Thank you for that. So this next question that we have is, what will local review boards allow us to do again? I'll give Davon a break and answer this question. So under HB 670, those police accountability boards that are mandated in each jurisdiction would be responsible for appointing a civilian to the trial board, receiving and reviewing complaints of police misconduct by members of the public, and a quarterly review of the charging decisions made by the Administrative Charging Committee. And this next question is directed to you, Davon, or anyone on the panel who would like to answer this question. Can you talk a little bit about the forces of resistance in Maryland that historically prevented meaningful police reform in the past? Democrats, Republicans, FOP, et cetera.
So the Law Enforcement Officer Bill of Rights, it's important for people to know. It emerged, so I mentioned in the overview that I gave, that there were urban rebellions around the United States during the 60s, many of which were the result of police killings of Black people. And so what was happening, a few things were happening simultaneously. You had the call for community oversight bodies. And even though it's hard to find, you got to go into the archives to really find it, there is sufficient documentation of advocacy of community oversight bodies with the kinds of powers that we described that we want out of the bills in this General Assembly. There's ample evidence of that. And police unions actually were vehemently against that. So much so that in a book that they actually produced, Yannette actually found it, so a shout out to Yannette for that. There's a book that the FOP actually published where they talk about they were able to increase their membership as a result of a campaign against the establishment of community oversight bodies. What happened simultaneously is that the LEOBR, there was actually an attempt to do it first on a federal level by a Maryland congressman. His name is escaping me now, but a Maryland Republican congressman attempted to do it on a federal level in 1971. It failed. So that's why they tried to then do it here in Maryland and it ultimately passed in 1974. Lastly on this though, it's important to also remember that the LEOBR emerges around the time when there are public disclosures of the counterintelligence program, which collaborated with local law enforcement in undermining, engaging in political assassinations, and other kinds of brutality and harm to liberation movements, which included the Black Freedom Movement, the New Left, the anti-war movement. So local law enforcement, the public disclosures that local law enforcement was collaborating. And so I don't think it's a coincidence that these things happen, at the same time. And it's my opinion to the question in terms of politically the resistance to this. The biggest, I think one of the ways that Republicans and Democrats have overlapped and their interests have converged is on the question of policing. In fact, in many of the more moderate or what we might call purple districts, both in Maryland and the United States, while these are districts that may be more progressive on issues like the environment, on things like LGBTQ issues of public safety and criminal justice, those districts tend to be more conservative on those areas. And I actually think that's one of the biggest problems that we have in Maryland, is that we have certain parts of the state that the Democrats find to be important political strongholds for whom are progressive on other things, but when it comes to public safety and criminal justice, tend to be conservative. And so it's really, and the Democratic Party has a supermajority. So it's really the only plausible explanation as to why it is that all the things that we've talked about on this webinar aren't just no-brainers if we're supposed to be this progressive state.
Thank you. Did anyone else on the panel want to take that question? This next one's for you, Monisha. We should be demanding that social workers are also culturally competent. Social workers are also agents of the state. Anything you want to respond to that?
Yeah, I think that's right. I agree with you. One thing that 496 does say with respect to schools being able to use the funds to hire social workers and counselors and school psychologists is it says that they should strive to hire these professionals in ways that reflect the demographics of their student body. We got advice from drafting. You can't really draft it stronger than that. You can't sort of require some particular ratio, require that they only hire folks of color, anything like that. But you can sort of include that as one of the measures they're supposed to pursue and that they would report on and so forth. So that's in there. It's part of the bill. It certainly doesn't address in full the cultural competence piece, and I think that's an important part of it. I think a lot of that work would have to be done more at the local level, and I think that with the reporting that's required by the bill on sort of how their student mental health services are really being done, that should be sort of part of the focus.
Misha, this next question is also for you. With the redirection of $10 million, what is the expected ratio for social workers, nurses, et cetera, compared to the current ratios?
I will try to pull up some data on this. I can't give you the ratios because I don't have the data that I would need from every school district in order to be able to do that. But what I can do is tell you that based on MSD data on the average salaries of these different professionals, if we were to redirect The $10 million state fund, that could get us, that could get us 106 or over 106 new school psychologists, or 112 new school social workers, or 126 new student counselors, or some combination of those in smaller amounts, based on the salary data that we have. And to be clear, this is across the state, so it's definitely not a panacea by any means. Truthfully, most of the money for SROs comes from local coffers, but it is an important start. As I said, a number of districts have used the state money to expand their SRO programs to more schools, to elementary levels, and in redirecting the funds would allow them to instead of expanding the school policing programs, they could expand their school social work staffing or their counselor staffing actually by greater numbers, because of the relative difference in the salaries between what police are getting paid versus these other positions. I'm happy to share too a great analysis that the Maryland Center for Economic Policy filed in support of our bills, that speaks in more specific terms to that trade-off, sort of how could we improve our ratios if we were to reduce our school police presence.
Thanks, Manisha. And this next question is for you, Davon. Under the House Leopold repeal bill, can police chiefs discipline officers without appeal to members of the police force?
If I understand the question correctly, the police chief, so the way the trial board system works, I'm assuming that's what the question is referring to. Police chief hands down discipline, the officer can decide not to accept discipline. And that trial board, as I understand it, that trial board decision is binding, right? So they would be able to override the police chief's determination of discipline, which mirrors the current system. I think the proponents of House Bill 670 would describe the difference in that it wouldn't just be the composition would be different, be a civilian administrative law judge and a police officer of equal rank.
Kicking it back to you, Monisha, the question is, would it be prudent to mandate a restorative justice requirement in schools in lieu of school police?
So there's actually existing law that says that school districts are supposed to have restorative approaches as sort of part of their student discipline plan. So there's somewhat of a requirement there already. I will say that it's a fairly modest one, but I can direct you to the statutory site, and it's something that folks should definitely use to advocate at the local level with their school boards and say, okay, hey, so where is your restorative approaches policy? And how are you ensuring that student discipline is rehabilitative rather than purely punitive? Because that's also in that sort of same provision. So, that's just to let you know about what's already there. In terms of mandating restorative justice or mandating a lot of the other strategies and interventions we really know work, like trauma-informed practices and so forth. I think it's a great idea. I think there's no legislation that's being put forward this year, and I think it would be tough to really get a mandate like that at the state level. But I think there was a bill a couple of years ago to create a restorative approaches state fund. And in some ways it's similar to what we're talking about today with redirecting the SRO fund. But all that's to say that in addition to imposing requirements, the state really can support districts that are already trying to expand restorative approaches by putting in some state money into those efforts. Baltimore City got a whole bunch of grant funding to dramatically expand restorative justice in its schools over the last few years, and saw a 44% decline in suspension. So that's just sort of one example of the kind of impact it can have. Also an example of how it takes money to really do it in an effective and comprehensive way. So I'd love to see the state bringing back that effort to develop a really robust state fund to support restorative justice in schools.
Thank you, Manisha. This next question is for you, Davon. Is that Dem perception regarding the purple districts based on any actual data, or an assumption by white Dems that other white Dems are inherently pro-police? Is there any polling that substantiates that regressive inclination?
So I would say that I think there is some evidence of that. It would probably require an entirely different platform to go through, like polls that elected officials have done, or candidates for office have done in particular jurisdictions. I would say that the most, so that's one piece. I would say that a part of the place where the assumption lies is in some of the kind of internal inside baseball conversation that you'll hear about leadership wanting to protect Democrats in purple districts. And so, an advocacy that I've done, I'm sure others, who are in the kind of criminal justice arena have done, in talking to leadership, have encountered because I know I have encountered one of the considerations, which is we want to make sure that our Democrats in our purple districts are protected. So while, like I said, I think there's a variety of polling that candidates for office have done that, we could break down and pull together, do a whole thing on that, where it's certainly clear that leadership believes that as well. And it's in part why there's resistance to many of the reforms and other kinds of criminal justice reforms that folks have put forward.
Thank you. So this question is for everybody on the panel, and it's police who commit intentional misconduct and cover-ups are often promoted to head internal affairs. Do you agree this should be unlawful?
Can you repeat that?
Police who commit intentional misconduct and cover-ups are often promoted to head of internal affairs. Do you agree this should be unlawful?
Yeah, I think most people would say, yeah, that should be unlawful. I think the difficulty is how legislatively, I don't know that there's a legislative solution to that, except for greater levels of transparency, where that's something that the public can pressure police chiefs and other higher level officials not to do.
Yeah, piggybacking off of Davon, it's like, if we don't even have access to the police records, how can we expose that? And so all these different bills and efforts that folks are talking about are necessary to get to the bottom of that. It's not just one or local control or LOBR. We need all of them to really be able to flex that out.
Thank you. I know we still have a couple of questions still coming in, but repeated question that we've seen is folks asking, how can activists take action at this time? And specifically asking about opportunities to impact legislators as police reform package bills go to conference. I'll let folks on the panel go, and then I'll go.
So, I mean, I'm sure we'd all say at some level, contact your lawmakers, right? And reiterate these 5 demands, right? And ACLU has made it really easy. I see it's been posted in the chat a few times, and I'm sure it's on Twitter and the Facebook feed. You can pull up the toolkits for more information and for sample constituent contact emails and scripts and so forth. And we'll keep those updated with the latest as these things go through different iterations. And I would say at the same time that you're doing that work, which is so important, sort of talk to folks in your own community about these same issues. You know, I'll say with respect to police-free schools, it's not just the sort of usual suspects that are really struggling to come around. There's a lot of folks, you know, parents who, of course, you know, have seen all the stories of horrific school shootings and have been given the standard narrative in this country, which is that the solution is to, you know, increase police presence in our schools. And so they've equated police presence with safety. And so there's an opportunity to really, and that's, you know, I get that, right? And it's really, there's an opportunity to educate, right? And explain that actually, you know, makes sense that one might think that. In fact, it's been studied over the last 40 years. Police presence in schools does not stop school shootings. It does not reduce any type of school-based violence at all. And, you know, just last month, there was a study showing that police presence in schools was actually associated with a 3-fold increase in the number of fatalities resulting from a school shooting. So these things are counterintuitive to folks. So part of the work, in addition to contacting your lawmakers, you know, frequently and loudly and often, is to educate your neighbors and your friends, and not necessarily assume that everyone's in the same place on these issues, and really and try to engage with them about why they think the things they do, and is that reflective of sort of how things really are.
100% agree. Just to add to that, I know usually you would encourage calls, but since everything is kind of virtual, folks are not in their office like they typically would be. So email is the most effective. Like Monisha mentioned, if you go on to the MCJPA.org, that's our coalition website, there are toolkits, scripts, action, social media sample tweets and posts that you can share, but definitely echoing, reaching out to folks who aren't on this call, your neighbors, family members, folks you go to church with, sharing the information with them and encouraging them to also push out this information. And if there's wondering if anybody else on the call had any other additional thoughts they want to share. And if I'm not sure if Manisha said this as well, but social media as well is a great tool as well. So utilize that. There is an updated action alert for conference committee that you all should sign and share. And then in addition to that, a sample toolkit for conference committee as well. And we have a couple more questions. This one is for everyone on the panel. Even in supposedly progressive MoCo, you get difficulty passing police reform, not just purple districts. Does anyone else comment on that?
I would definitely just second Davon's assertion that both Democrats and Republicans are in on this idea of safety being backed by and enforced through law enforcement, right? And they're also essentially doubling down on capitalism, which is the foundation of the police school to prison pipeline and the mass incarceration project in general, right? So police exist to protect our elite and to protect property and profit. So, I mean, ultimately there's an economic base undergirding all of this. And that's why it crosses over both parties.
Two things to say quickly to that. One is that to the question. One is, or the statement. One is that that the conversation around purple districts is an explanation around what leadership says to justify its conservatism on these issues. That's different from whether or not electorally it's true, right? So it may not actually be true that taking a more progressive stance will result in penalties electorally in those purple districts, but it's the rationale that leadership uses in order to kind of order its steps in terms of what it prioritizes, what it puts forward. And then the second thing I'll say is that I think regardless of party, this is to what Rob said, regardless of our party, I think generally this society is conservative on issues of criminal justice and public safety, because these are the issues that in some respects animate a lot of the anti-Black antagonisms that all of us are socialized, like the stigmas of inherent criminality and the inherent pathology of Black people is ubiquitous. It's a part of every aspect of civil society. And so public safety, criminal justice is the place where those things are most triggered. And I think this is where we get where there is social science to justify the policies we support. This is where we get the kind of irrationality in terms of the stated opposition to these positions that, again, usually aren't based in social science, but are usually based on the racialized imagination that folks have projected onto Black people that become a part of the resistance we get, even from so-called progressives.
Thank you. Next question. There is a tendency when lawmakers pass an inadequate bill for them to declare victory, and then it becomes more difficult to make further progress in subsequent years than if the flawed bill had never passed at all, because the general public may not fully understand the details. How do we address this when looking at the versions of Leopold repeal that are currently on the table?
I missed the first part of that question.
There is a tendency when lawmakers pass an inadequate bill for them to declare victory, and then it becomes more difficult to make further progress in subsequent years than if the flawed bill had never passed at all, because the general public may not fully understand the details. How do we address this when looking at the versions of Leopold repeal that are currently on the table?
I would say that it's generally true that things become harder to pass when the legislature passes like what they would consider landmark legislation. I think that's generally true, but I don't think that we should limit ourselves and our political activity to those moments. So I think that even though we won't get all we want, regardless of what passes, we should continue to press for what we need. And I actually think that the information that we're going to get from the public disclosures will create some ammunition for the need for community oversight.
Thank you. This next question is, another of Delegate Acevedo's amendments was rejected without roll call, which would have added a mechanism requiring police agencies to screen out white nationals from their ranks. I'm sorry, for the wrong question. What do you see as the likelihood that more community control of police discipline can be achieved in conference committee?
What do you think, Yannette? I feel like I'm answering all these. What do you think?
I feel like you're going to say that. I think it depends on the pressure that the people put on their legislators, both the leadership who is, that drives the decisions, but also your individual legislators, asking them to speak up on behalf of what your community is asking for. So that's one way to do it. And really, the legislator will go as far as the people push them.
I think what you think.
I saw a comment or question of whether they actually count how many queries they get from constituents. Yes. Contacting your legislators works. And I saw another piece about whether we should target corporations that back these folks. But that is a long game approach. We don't have that kind of time. Right now, you just need to contact your legislators.
And I will just add that with next year being an election year, this is the perfect time to reaching out to your legislators So definitely just echoing what folks said. It's critical and it does make a difference.
Yeah, and I'll just echoing that. I have been in meetings with lawmakers where they will reference the number of emails they got on an issue. So, you know, and it's not that they're responding to all of these, but that's their staff's job to tally up what they're hearing about, and they do mention it.
I can co-sign as a former staffer, that is their job, and it does make a difference when you get volumes of emails on one specific issue, especially urging them to vote a certain way. So definitely echo that. Next, and we'll probably have to take a couple more questions. This next question is for the group. How active are liberal and non-civil rights based activists on this issue?
Sorry, can you repeat the question?
How active are the liberal, non-civil rights based activists on this issue?
Well, I'm not sure I have an answer to that exactly, but I do think it's really significant that the Maryland Coalition for Justice and Police Accountability includes something like 100 different organizations from around the state, some of which certainly are organizations that would define themselves as civil rights organizations, others of which are not. You know, they're youth advocacy organizations, they're organizations focused on democracy. So there's a range of perspective, you know, whether you're concerned about issues of racial justice or of civil liberties. You know, there's folks, I think, coming to this table from different places. And so I think that itself, the membership of this coalition, speaks to that range of perspectives. Not to mention, you know, people who themselves have been impacted directly by the issues we're seeking to address, which is really, I think, ultimately, I don't know if you would call that a civil rights perspective or what, that's a survival perspective, right? And that ultimately is and should be at the heart of this push.
This isn't necessarily an answer to the question, but I feel like the question prompts what I'm about to say, which is that I think during this General Assembly, there's been a lot of you know, marching and rallying by a variety of different organizations, both within and adjacent to the coalition. And we've gotten, as a result of that, legislators that are upset because it damages their conception of themselves as progressive champions. And what I want to encourage people to do is continue, because I think the standard has been very low over, you know, just generally the standard has been very low. And so I want us, as folks are engaging elected officials, that will try to tell you why they are true progressive champions, that we continue to hold the bar really high and we continue to put pressure on them. Because it is the coalition's position that we've gotten what we've been able to get as a result of the pressure that folks have put on people in elected office.
And this next question is kind of a technical question. The question is, what does it mean for an amendment to be rejected without a roll call? So that just means when there's an amendment put on the floor, there can either be a vote by voice, or they can call a roll call where you see everyone who actually voted on the bill. So if you're paying attention to the floor debate on HB 670, there was a roll call on the Police Free Schools Amendment, but there was not a roll call on the other amendments that Delegate Rossero introduced. And I believe it requires other folks in the body to stand up in order for a roll call to be called. And so I believe there were some Republicans that stood up for the Police Free Schools one, so that one received a roll call. And this other question is, do emails outside of Maryland count to these legislators? So I would say that no, it doesn't. As a former staffer, whenever I got an email and there was an address at the bottom, the first thing I did before responding is checking what district that they live in. If they lived outside of my legislator's district, I forwarded it to the appropriate legislator, but it means a lot more when they know that you live in their district and are following closely what and how they vote during the legislative session on specific issues.
Yeah, and so it's good to put your address down there. So it's very clear that you're in the district of the person you're contacting. And you can go to mdelect.net if you're not sure who your representatives are. You can just put in your address and then you'll get the names and can click on the links for contact information.
So that brings us to the conclusion of our town hall. For those of you who are interested in joining the coalition and have not joined the coalition, there will be a link dropped in the chat for you to fill out a form. And for folks who just want to either just be on the listserv and get the updates that we send out frequently, or want to play a more active role in organizing folks in your community and districts, encourage you to reach out and join the coalition. In addition to that, there's the action alert that's been dropped in the chat and a social media toolkit that I'm dropping in just a second.